Good morning. Apart from pecuniary remedies, we also looked at non-pecuniary remedies across the jurisdictions that we've studied in this global toolbox. And we see that there are a variety of these remedies to account for the multifaceted corporate climate change litigation that we have existing in these jurisdictions, as well as the impact of climate change itself would account for a lot of factors. And we see that the most common would be injunctions, where courts would order a corporation or an entity to do something or to refrain from doing something in countries like Canada, Brazil. We also have in the US as well as in Poland, injunctions exist. And of course, they also, in some form or in some way, are present in the other jurisdictions that we've studied. Declaratory relief will also be present in that there are always remedies, whether they are called declaratory relief or some other name, that will declare the rights and the duties of the parties to a particular action. Ohenda, for example, established duties relating to climate change mitigation by anchoring that in their civil code's duty of care. The Jonah Gembre case was about the responsibilities or duties of oil and gas companies in their gas flaring activities in relation to the constitutional rights to life and to health and dignity. Preventive measures are also common across these jurisdictions, and they mostly target behaviors of corporation. For example, in the Notre Dame case in France, we have a court ordering a corporation or entities to prepare their vigilance plans on the basis of their duty of vigilance. And so there is a way of preparing for potential harms that might happen or might occur out of their activities. Restorative measures like repair in the German case of the UYA, where there was sharing of costs in order to repair or restore a particular area because of the consequences of the activities of the energy corporation there, is also an example of that. We also have corrective actions and public civil actions. In corrective actions, we see that in the Mehta case in India, which established the absolute liability rule, and the Ibama case, for example, that was really anchored on the protection of collective rights. And so public interest litigation is also rich in these jurisdictions. In the Philippines, we have special writs called the writ of continuum mandamus. In the case of the cleanup of Manila Bay, this was a continuing order of the court to clean the body of water and to report at regular intervals. There is also the writ of kalikasan, which was issued by two indigenous cultural communities against mining activities of a corporation. Citizen suits, which also grant for liberal standing, was explored, and certain reliefs were granted in the resident marine mammals case, which is a landmark case in the Philippines that declared a service contract for exploration of oil as unconstitutional. Specific performance orders, in particular in the UK, also combine features of these preventive, restorative, and corrective measures that we've already discussed. And so these are the remedies, the non-pecuniary remedies that target so many of the aspects of the impacts of climate change. And in many cases, the courts tailor these remedies to address or to target the specific problem that was part of the case before them. So, given all these non-pecuniary remedies, do we still have challenges? Yes, we still have challenges, and mostly they stem from the peculiarities of the legal tradition that we are talking about. It has something to do with the hesitation of the courts, for example, to recognize particular rights or emerging rights because of the way in which rights are identified in their jurisdictions, and some are more open and some less so. We also have the major consideration of the economy and economic impact. In the Alar Eru case, for example, in Nigeria, while the plaintiffs there were granted damages, the court stopped short of issuing injunctions because that would be tantamount to making the corporation stop its operations in the area, and that would cause such an economic disruption. And therefore, the economic consideration outweighed, in so to speak, the violations and the reliefs that would have addressed the particular problem that they were encountering here. Together with the legal tradition, of course, you have judicial approaches that might lean towards more restraint. And part of that really is also factors like how to satisfy causation issues and the high threshold of satisfying as well concrete danger. And we see that in Japan in the case of the Kobe coal-fired power plant, where concrete danger was not established according to the court. And in the Philippines, you have, and I would suppose in across jurisdictions, you always have the problem of effective implementation and enforcement. And so while they may be granted by courts, we have a question of how to enforce these orders, given the nature of corporate entities and their operations, as well as the just this enormity of the problem of climate change and addressing or targeting the particular impact, also because it is difficult to see how much effect the implementation of the order would be given the nature of the phenomenon that we are talking about. But the future is not bleak. Non-pecuniary remedies allow us to think about further steps and how to fashion these remedies so that we are able to effectively address the problem through corporate climate change litigation. And these remedies tell us that more and more we see the multifaceted nature of the problem, and so that it's also multi-directed in the sense that the non-pecuniary remedies do not only target a particular problem, but actually many parts of the problem, and therefore they work together to make the situation better. They are also mostly preventive and restorative. In the case of Xunjiang County in China, the carbon sinks approach and its policy resulting out of that case was helpful in imagining what could be a restorative approach. And so the takeaway here for all these non-pecuniary remedies is that they're all anchored on rights, whether we're talking about declaratory relief or clear legal rights in the case of injunctions. These are all rights-based remedies, particularly in public interest litigation, where you have collective rights emphasized in some of those cases. And they tell us that courts often engage in balancing of certain interests, environmental protection and addressing climate change on the one hand, and of course, economic considerations and particular legal traditions on the other, and what that might mean for their norm formation and the availability of remedies and the ease of use of these remedies in these jurisdictions. And often, as we've seen throughout this morning's presentations, a lot of these jurisdictions inform each other in how this balancing often happens. All right, so thank you very much for listening.